that it's a frequent occurrence for us. And I could hear you, but I think the rest couldn't. And we take seriously the need to fulfill that promise from Congress that no person will experience discrimination. So we try to move as quickly as we can. We try to use all of the tools that we have. That means that we use guidance to share information about what the law is and how we expect to enforce it. We also enforce, which means that we are investigating conditions in schools and we are engaged in active re-regulating at the moment, which is a new muscle for us and certainly an active one now. So that's our broad mission.
So justice and a lot of justice.
Yes,
okay.
Yes, as much as we can.
So this is not your first time in this role. You were the Assistant Secretary for Civil Rights under the Obama administration. Why come back? Why do this again?
Well, first, I didn't want to leave. Let me just be clear. The career staff in the department, when I was needing to leave at the end of the Obama administration, gave me repeated reminders that it would be unseemly for security to have to walk me out. So I had a promise I will actually go, but it was the last day and I was devastated to leave. And it was incredibly hard to be away from the office for the time when I was away. I'm a lifelong civil rights lawyer, which you didn't say, but I will just out myself with it. I had spent 17 years mostly suing government before coming to government. And so I had a lot of views about what I wanted government to do. And then when I came and became government, I saw how much change we can make, how quickly. And there's really no place else in the country where I can do as much good as I can at the Office for Civil Rights. And so I was desperate to be back. I will be devastated when I have to leave again. I'm really hoping that that's not for another 5.5 years, I will just say. But the putting the spin or the gloss aside, the work that we see is extraordinary. And the ability to make change for millions of people that is consistent with our country's highest aspirations, with our country's promises that are bipartisan over 6 decades about what civil rights should mean at the desktop for students. There's really no other way to have that kind of reach and to make that kind of difference. And that's what gets me up in the morning. So that's why I came back.
Well, we're happy that you did.
Thank you.
I'm very glad. There's a lot of conversation right now around the words diversity, equity, and inclusion. As the Assistant Secretary for Civil Rights, what do those words mean to you? Well,
I will say they mean to me what the president has said they mean. The president issued an executive order about diversity, equity, inclusion, and access. And for us as a country, I think they need to mean that each of us is respected for who we are and for the whole person, for all of the ways that we show up in the world. And that from a civil rights perspective, we don't experience harm on the basis of those identity characteristics that are protected and have been protected now over decades. So my job is to ensure externally, so in schools, that students are able to focus on reading, writing, arithmetic, and not on harm and discrimination based on assumption or stereotype or actuality of their identity characteristics. And that's incredibly important. We also try to live that in our own practice and in our internal work, but I don't have internal employment enforcement responsibility in my office, which some of the other federal civil rights agencies do.
What do those words mean to you as a parent?
So I'll just say I have 2 kids. One is in college now, and the other is in high school. And I am fierce about making sure that my kids have every opportunity that we say every kid should have. So I am that parent in school, I will just say. But I also feel like for the 49 million P-12 students in the country, the 18 million higher education students in the country, that each of them deserves the promise that I make to my own 2 children, and that we need to be treating every student in school as if that student is someone's precious baby, and that student deserves to live their dreams and to be able to fulfill their complete aspirations for who they will be. And our schools are designed to offer that and should be that for every student.
Yeah, thank you. So I want to talk to you a little bit about students for fair admission and the recent Supreme Court opinion. So that opinion drastically altered, upended 40 years of precedent for how colleges and universities can consider race as one of many factors in the admissions process. What does that decision mean for you? And then also, what does it mean for educational opportunity in America?
Sure. Well, I mean, first, I enforce that decision, and I enforce the law that decision describes. So it means a very changed practice for me in the Office for Civil Rights. We have already received complaints responsive to the court's decision, challenging university admissions practices and asking us to examine those practices in light of the decision. So it will be a new day for us in how we enforce and what we will do. And as you mentioned, it upended 45 years of practice in schools. And as I mentioned, there's roughly 6,000 colleges and universities. Some 200 of them had been engaging in some form of use of race in their admissions practices. And that number, among others, will likely need to reconsider how they consider race, if they consider race, when engaged in their admissions practices. What I think it means for us as a country to see that kind of sea change in the law and sea change in our shared understanding of what is an available tool is an opportunity, welcome or not, is an opportunity to reconsider what and how we do the work to admit, retain, support, and graduate diverse classes. And nothing in the Supreme Court's decision challenges the ability to engage in those practices. And so my hope is that colleges and universities that were interested to ensure that they educate richly diverse classes persist in a commitment to educate richly diverse classes. Some colleges that weren't committed maybe could start to be committed also. I would welcome that. And it is time for us to be thinking about how do we do that work well, and what new opportunities are available to us now that the maybe what was a crutch that we had been using is no longer available to us. So what will be there instead? And I will just say, in case anybody doesn't know, the president promised, and we delivered at the Department of Education, the Department of Justice, to within 45 days of the court's decision issue a set of resources that describe what the law is and what is still available. We are very clear. The court did not take away the ability to seek a diverse class, to educate a diverse class. The court did not speak to more than it did in the Harvard and University of North Carolina admissions practices. So it didn't address other issues. And that leaves a very wide variety of available options still to make sure that we are educating diverse classes of students, and that we not only bring them, but we keep them and we graduate them and we prepare them, and that they are our future. So that we were concrete and specific about some kinds of tools that are still available. They include reviewing data, they include recruitment strategies, they include work on belonging, work on making sure that students feel like their campuses are for them, and offer a pretty wide open field for the coalition of the willing, and I hope that coalition is wide.
Thank you. I thought it was interesting that in this conversation, you all did focus on belonging and a sense of belonging. Why is that important in the educational context and, for colleges and universities to not only focus on admissions and bringing in a diverse, campus, but also retaining one? Why is that so important for education in America?
Well, first, we want people to be educated. So, I mean, if we don't retain people, then we haven't fulfilled our purpose. So, just that at the very core, that is a mechanistic, important element for us. But separate and apart from that, in my work to enforce Congress' promise that no person will experience discrimination on the basis of race, sex, or disability in particular, what I see all too often are the ugly effects of harassment, the ugly effects of the ugly and unlawful effects of a hostile environment that prevents a student from being able to benefit from education, from being able to focus in class on math or physics or whatever the subject is at hand. If students are denigrated for who they are, if students are subject to stereotypes about who they are and made to feel like they aren't part of the class, they aren't welcome, they aren't part of the full community, then then our law is violated. I mean, that is a core component of non-discrimination. And so why is it important for school communities to focus on belonging? Because the law demands it. I mean, to say Congress said so, but also we will not keep our kids in school. We will not educate and support the next Ketanji Brown Jacksons. We will not be developing the leaders who will do the things that we need done in our society if we don't welcome them in the community, nurture them, and make sure that they can complete their educational journey.
So you mentioned something about, complaints and like specific instances of discrimination, and, your office reviews them and goes through this. Can you just tell us, I think sometimes we talk about civil rights, violations in the abstract, but like, what do we see? Yeah. Where are you seeing? Where are some examples of that?
Well, I guess I'll say several things. The last fiscal year, our fiscal year goes October 1 to September 30. And the last fiscal year, we saw the highest number of complaints that we've ever seen in the history of the Office for Civil Rights. That was close to 19,000 complaints that came into us. And that's not good news, I think. I mean, on the one hand, I think I am pleased that people believe government will be there for them. I'm pleased that people are coming to us with their deepest hurts and expecting redress, because that's our job, and I'm pleased to deliver. On the other hand, the volume, complexity, range of kinds of harms that we see in this time, certainly the allegations that come in the complaints, are astonishing. And some of them are, the old style discrimination that, it's going to happen and you thought it was coming. And some of them are new and astonishing things that you didn't know somebody could do to another person, right? that we hear about. And the COVID context has created a new and different overlay for kinds of harms that might get visited on children, on students. And so that's hard and painful to see. My staff are terrific. I think we're equal to the task, although it is challenging to deliver just as quickly with that degree of complaint coming in. We have 18% fewer staff investigating than the last time we had the next highest complaint volume, which was also last time I was here. Maybe it's me, but at the end of FY16, we had about 16,000 complaints and 18% more staff. So it's a hard time to be doing the work. But let me tell you some of the kinds of cases that we resolved and kinds of justice that we see. I talked about harassment and talked about hostile environment. Let me make that not abstract. We had last winter, we resolved a case in a school district in Iowa where a Black student was subjected over and over and over again to a racially hostile environment that his school didn't respond to appropriately. And just to really contextualize it, 6% of the kids in his school were Black. So it was already an isolated experience for the student. And in this school district, shortly after the George Floyd murder, white student knelt on a Gatorade bottle and looked at this Black student and said, "I can't breathe," as a way of harassing the student. And the principal didn't view that as racial harassment, which it was, let me just say, but the principal didn't recognize that as rising to the level of race harassment, even though it was also in the context of the student being called a cotton picker, called a monkey, had students saying the KKK is the cool kids club at the school. It's over and over and over, really ugly harassment. It's a middle school student. He was reduced to tears in class, and that is not common among middle school boys. And he was reduced to tears because he was watching a documentary about Harry and thinking about his own experience in school and receiving inconsistent and insufficient response from the school district. And that's not how a child should have to learn. That's not what we expect when we send our kids to school. And by the way, just as a reminder, school is compulsory in K-12. So, this child was required to be in school every day, and the learning environment for the student was so ugly about who he is. And he and his mom were complaining to the school district, and the administrators whose job it is to support him were turning away. and saying it's not that bad. It's not that it doesn't matter. And it does matter. The federal government now says it matters. They're subject to federal monitoring, and that kid is okay now, and they're paying for counseling. So, I feel good about what we're doing for him, but appalled that it took federal intervention, and it took a little white knuckle negotiating to get this district to realize that they actually needed to change their practices. And that's very far from isolated. And another recent resolution was, this was in an Arizona school district where a Black mother came to us and complained that her Black daughter repeatedly had white teachers touching her hair, and she would ask them not to touch her hair, and they kept doing it. And when we looked in the files, we found the teachers saying, "Oh, she needs somebody to tell her that she's beautiful, and so I'm doing this, and she should be grateful." And I was like, "Ooh, there's more to the story than I expected when when we first got that in the complaint." But that was the locus of the complaint, and we confirmed that had happened and needed to change. But we also, in the course of investigation, found out about rampant race harassment across racial identities, ugly anti-Semitic slurs, and people holding up their eyes to mock Asian students, and just, pick your category, just rampant race harassment that was taking place in the district without district response. And I'm grateful that we found out, but it wasn't what this mom happened to know about, and so hadn't told us about it. And so we needed a much more systemic resolution than we might have thought going in, to try to ensure that the district could make sure that students would be safe. And again, they're subject to federal monitoring. We are there to make sure that kids are okay, and I'm glad we could do it. But when we think about school, and I know yesterday was the first day of school in area school districts here, and when we think about sending our kids to school, they have a new backpack, they maybe have a new lunchbox. You think about, I hope you like your teacher, I would like you to step straight in class. We aren't thinking necessarily that we have to say, I want to steel you against the things somebody might call you, the things someone might say to you in school. That's not the image of what school should be, and it's not what Congress promises your school won't be. And so, I'm very grateful that we can be there when that happens. And I am enormously distressed by the routinity now with which we are seeing that kind of harassment in school, and insufficient school response. And I'll just say more. You didn't ask this, but I'll just say more. In this time, there's a lot of polarization about schools in particular, and a lot of polarization in our public discourse about how thick-skinned people should be, or what we should be expecting in school. And I think in those conversations we don't talk enough, we don't think enough about what we're asking our babies to hold, and the toll it takes on them to have to navigate that while trying to write an essay, while trying to learn history. And that it makes me sick as a mom. It makes me sick as the chief civil rights enforcer in the nation's schools, and it makes me worry about our democracy.
So this conversation hits close to home for me because my son just started first grade yesterday. And I do worry about some of those things. So how do we address the routinity? How do we fix that, ensure that my son, other kids, when they're going back to school, don't have to shoulder so much, in the classroom, and can have environments that they're forced to be in. You mentioned are compulsory, but also respectful, safe, inclusive environments as well.
Yeah. Well, 19,000 of us have come to the Office for Civil Rights, so thank you for that. And that's one path. I think we're issuing a lot of resources to try to share what the law is, and those are things that people can use themselves when advocating with the teacher, with the school district, with the school board, with the university. Those are materials that people can have at the ready. And I will say, certainly in my time in the bad years when I couldn't be at the Office for Civil Rights, my kids were in school, and I did sometimes take a dear colleague letter and say, I signed it. I just want to make sure you saw it. This is actually what the law is, just to make sure that my kids' schools, among other kids' schools, do fully comply. But I also hope that we are active participants in our kids' schooling. And I say our kids' schooling, meaning that very broadly. If you don't have a kid in school, I hope you're volunteering in a school. If you do have a kid in school, I hope you're volunteering in a school. That we can be active participants in our school communities and work to ensure that they are the communities that we say they will be, right? And often when I and my office see discrimination, it's not because an educator wanted to hurt a child. It was because somebody didn't know what the law was and didn't know how they were supposed to respond. And so let's help them to know and to make sure that we are fully responsive to our whole school communities.
What do you think is the biggest threat to civil rights in education right now?
Well, I'm not going to pick one. That the reality is Thomas Jefferson is famous for having said that the price of liberty is eternal vigilance. And the reality is that we have to always be vigilant about civil rights anywhere and civil rights in schools in particular. Every school year is a new opportunity to discriminate. And so we are always having to remind, always having to start again and to work on the class in front of us today to make sure that it is a safe and appropriate and lawful, non-discriminatory space. So one challenge is, it's still our challenge, right? You know, that we have now 6 decades of promises about who we will be as a country and what the federal backstop against harm will be. And we've never achieved that. So it's, you know, that we're always working toward it is an ongoing and I think very big challenge. The other very big challenges are that no child has a minute to waste of learning. So nobody can withstand another day where their rights aren't met at school, and there's no time. So the urgency is intense, and the new varieties of ways that we find challenge. You know, we are in a pandemic still. You know, we are coming through a change of that was unimaginable to us before 5 years ago, and we are living through that time. All of us struggling through that, and our kids are shaped by it. Their educators are shaped by it. Their communities are shaped by it. So, you know, that is an ongoing challenge. And the ways that we show up, the different needs that kids bring, you know, they're very different. I mean, each of us is an individual, right? And it's among the amazing things of the human condition. And it is also hard every day to make sure that every minute of every instructional day, we are satisfying all the needs of the kids in front of us. That's an enormous challenge.
So you talked about how we're fighting for something that we haven't achieved yet. And actually just want to read something from the guidance because I loved it. I thought it was well said, where you say, we've seen that there are no simple answers for unwinding the entrenched roots and sprawling branches of segregation and discrimination. I guess my question is, you know, why should we not give into temptation, you know, that there aren't any easy fixes when it comes to discrimination? Why should colleges, universities, and schools, and really all of us, still remain committed and vigilant, like you said, to fixing something that we haven't fixed yet and may never fix?
We're going to fix it.
We're going to fix it? Okay, good. Forgive me for being a pessimist. I apologize.
The alternative is worse. That if we are not vigilant, if we are not protective, then I think we are at the abyss, right? So the alternative is worse. And let me concretize that. I mean, to say, you know, I will out myself again. I keep outing myself on things, but you know, I am a civil rights lawyer, which means I'm an eternal optimist. And you know, you don't keep pushing the rock up the hill unless you think you might actually get it up there sometime. So, you know, you take what I say with a grain of salt. But my mother was 10 years old the year that Brown versus Board of Education was decided, and she attended schools in racially segregated schools in Richmond, Virginia, before and after Brown. The decision never impacted the circumstances of her schooling, and you know that is a history. I hope we all know that Virginia wasn't eager to change its practices so that it offered integrated schooling for kids. And my mother, growing up, couldn't try a hat on in a department store, and she rode the back of the bus by law. And my father's white, my mother's black. They couldn't marry in my mother's home state of Virginia because Loving versus Virginia hadn't been decided yet, and they married in my great aunt's backyard in Washington, D.C., because that was lawful for them here. And they honeymooned in national parks because it was lawful for them to be together in national parks and not many other places. That is not our history. That was my mother's life. And when my mother raised me and my brother, she promised us we could be anybody we wanted to be. And she knew that wasn't true, but that was a promise because it was her aspiration. And certainly my life experience was dramatically more open than hers had been. I didn't attend de jure racially segregated schools, although in California, where I grew up, the schools I attended were desegregated by court order. So, do with that what you will. but they weren't de jure segregated schools. I had substantially more opportunity available to me than my mother did. Affirmative action was alive and well when I was applying to college and to law school, and I was able to go to places that were the places that I dreamed about. And as I raise my children with broader and more wide open expectations, even than my mother promised to me and hoped that she would be able to deliver, even though she didn't have a reason to expect it. So why do we do the work, even though we haven't actually lived our aspirations yet? We do it because we hope. We do it because we want to. We do it because we believe that things will be better for those who come after us. And we do it because when we are not vigilant about it, we are so circumscribed, we lose so much in our rights. And that is so dangerous for us. So for me, you do it because there is no other alternative.
So what's next for the Office of Civil Rights? I know, at least as far as the affirmative action decision goes, release some guidance, and then also saw like most recent guidance released last week. What's next as far as keeping this momentum going and making sure that everyone has the resources that they need to live in compliance, but also keep pushing forward for more inclusive campuses and schools?
So I'll say several things. One, I liked your point about momentum. That when I came to the Office for Civil Rights in 2013, the most guidance we'd ever issued in a single year was 4. And this last year we issued seven guidance documents, and this year we've issued 9 on race and shared ancestry and national origin alone, and many more. In the total years of the Obama administration, we issued 38 resource documents. So, I think it's important to speak to what rights might be and help equip school communities to be able to fulfill the law. So I think that's what's next is there will be more of that and more enforcement and more work. But the second document, the document just from last Friday that you mentioned, I want to speak to too, because it's a companion of a sort to the response to the students for fair admissions decision that analyzed what's available, what's left. The resource last week is instructive for school communities about how they can still offer racially inclusive programming and what is available. And there's so much public conversation now about whether DEI activities are lawful and whether they are even good policy goals, whether they should be taking place in schools. And I really want school communities to hear from me an emphatic yes, that federal law does not categorically bar those kinds of activities. And there are circumstances under which it's actually required. And I will say, A, it's not my opinion, it is what the law is, but B, is what the law. So just to say that, there was a lot of rhetoric in the last administration. There's a lot of rhetoric now among people who are not President Biden about whether DEI activities, should be something that we don't engage in. But I've had occasion to canvass OCR's, the Office for Civil Rights, resolution agreements in the Trump years and in the Obama years and now. Now I get to see them because I'm signing them. But I'm looking at what the office has done consistently over time. And in the Trump years, we routinely were requiring school districts to engage in implicit bias training, to review data, and to bring in people to train people about racially hostile environments, because that was what the facts and investigation warranted. That's what a necessary response is to discrimination. And so when we talk about, well, we shouldn't be engaged in these activities, there are times we absolutely should. There's times when to offer equal educational opportunity, to remedy discrimination on the basis of race or sex or disability. That's exactly what you must do. And the law doesn't it's not a dirty word. It's not, it's not something that the law says that we shouldn't do. It's actually something that the law says we must do in some circumstances. And we were trying to get people, the school communities, to know that before they're required by us or by a court order to do it, but to actually think about the child who had kids call the kid a cotton picker, to call the kid really ugly names, and think about how would you want that school community to repair? How would you want that school community to respond? And there are the resource that we issued has examples of a pretty wide variety of kinds of circumstances that can come up, and that we do see come up in the kinds of investigations that we see. And we were, let me take a step back even from that. We were conscious in this last year. We've issued 2 documents really focused on anti-Semitism, really focused on the scourge of what appears to be a rise in anti-Semitic conduct, including in schools. And what we see when we see that kind of identity-based harassment take place in schools is a need to respond as a school community through DEI principles, right? And to educate a school community about why it is harmful to operate based on stereotypes, and to lessen someone's opportunity to learn based on ugly assumptions about who that person is. And so I'm happy to enforce. We're actively working on our enforcement, and also issuing press releases and trying to share why and when we need action. We're also trying to help school communities come into compliance without our having to need to slap their wrists, right? And to share what the law requires that we provide in our school community so our kids can be safe.
So there's this moment, and I think the convening the Department of Education held in response to the Supreme Court decision, where you reminded everyone that the Office for Civil Rights, the federal government, along with DOJ, are the ones who are responsible for enforcing those laws. And if you haven't heard from you all, then just keep that in mind. Why was that such an important reminder to remind everyone that you are, the federal government is tasked with enforcing and responsible for enforcing those laws?
I have been disturbed by the degree to which I see, I think, deliberate overread of recent court decisions, including the Students for Fair Admissions decision, and letters direction to school communities to take action that was not in the court's opinion, and to say that this must mean you cannot do these other things that the court didn't address. And some of them are things that the court explicitly didn't address. I mean, it said we are not addressing this question. And so then when I hear a member of Congress, when I hear state attorneys general, when I hear some activist groups sending letters to schools saying you should change these practices because the law demands it, I do think it's important to be clear that we issue Dear Colleague letters, and we do let people know what the law is, and we are pleased and honored to enforce the law exactly as courts interpret it and as exactly as Congress writes it. And if there is not a legal requirement to change course, then there is not a legal requirement to change course. And it is important to us to say when there is, and it's also important to be clear that there isn't.
So I've been hogging the conversation for quite a while now.
Thank
you. Yeah, thanks for being here. Want to open it up to our audience, ask questions. So we will come around to you with a microphone. Please wait till the microphone comes to you. Please state your name and affiliation before asking your one question. One question. We will hold you to that. Thank you.
Hi.
Hi.
Thank you so much for this. I'm curious, what does the Students for Fair Admissions decision mean for K-12 schools, if anything?
Not one thing. The Students for Fair Admissions decision was about Harvard and University of North Carolina admissions practices, and it doesn't address issues outside that area, including issues with respect to non-higher education practices. So the law is and has been that individual use of race warrants strict scrutiny, and that there's a particular legal test for how that applies. This resource that we issued last Friday does speak to that question and does address quite a bit of kinds of circumstances that can come up in K-12 circumstances. The Students for Fair Admissions decision doesn't address them, and so doesn't impact the practices in those school communities. So.
Hello, thank you for your talk.
Hi.
My name is Will Lyons. I am a Knauss Fellow within NOAA's Office of Education. That's short for the National Oceanic and Atmospheric Administration. And I'm also a PhD candidate at Florida Agricultural Mechanical University.
Wow, congratulations.
Thank you. Ready to defend. My question for you is, how has your work translated into outcomes for students and youth regarding environmental justice and the current Justice 40 initiatives of the Biden administration?
We are justice adjacent on the environmental justice work. That the Environmental Protection Agency has a civil rights office who have jurisdiction over that question specifically, and I am impressed with and cheering on my colleagues there. But typically, environmental justice questions would go to that office for enforcement. There are certainly environmental justice issues that can come up in schools, and the question of whether school facilities are safe and appropriate for students, and whether there are differences in available resources by race or by other protected categories that we have jurisdiction over. We would be able to address that question. So, for example, school communities are routinely lack air conditioning, and it's unsafe for kids to be in them, and it's too hot. That's certainly an environmental justice question. It's also a racial justice question that we would have jurisdiction over. So there are some places where we have an entree and we would be able to address the question, and then there's some places where it would be more appropriately addressed through the EPA Office for Civil Rights, but they're also terrific. So and truly delighted to be on it for that work too.
Hi, thank you for coming to speak with us. My name is Tanya Ter-Martinez. I am a research associate on the K-12 team here at CAP. And my question is, with the polarizing communities that exist on the internet, what is the role of media literacy and teaching about online safety in the K-12 space as it pertains to civil rights?
Yeah. I'm going to give you the lawyerly answer and a more human answer too. I'll just give you a preview that there are statutory restrictions on the Department of Education and the Office for Civil Rights as a part of the Department of Education setting or controlling school curriculum. So we are not able to set or control school curriculum. That's a choice that is locally made. And my office job is to enforce the law. And so we also don't make policy pronouncements about what we might like. We say this is what the law requires. But there are times when a question about what the law requires gets to a curricular choice. And so if the lens through which I can look at that question, and my team at the Office for Civil Rights can look at the question is the racially hostile environment lens, or the sexually hostile environment, or the disability hostile environment lens. If any school choice, including a curricular choice, lends itself to the creation or perpetuation or support of a hostile environment, then the school would need to take corrective action. It doesn't necessarily mean that they need to change the curricular choice, but it does mean that they would need to ensure that the environment is safe and appropriate for students to learn without discrimination. So we would be able to look at it that way. On my views as a citizen about the appropriate choices for literacy and democracy literacy and literacy about internet savvy work. I have lots of thoughts on it as a mom. I have lots of thoughts on it as a human being. But as the chief civil rights enforcer in the nation's schools, that's not an area that I get to delve too far into.
Thanks. And thank you for being here. I'm Mara Redmond, the Executive Vice President for Policy here at American Progress. Really appreciated the conversation very much with both of you. And thank you for joining us on this last week of August before school starts. I wanted to bring you back to the Supreme Court decision.
Sure.
And I noted that when Jared asked you the question, kind of entered the question, he talked about this changing 40 years of precedent. I heard in your response some of looking at, and I'll try not to use lawyer speak, but looking at the decision as narrowly as possible. I may have overheard that, but what I'm curious about is how you balance a very natural sentiment among people who care that the sky has fallen with a, maybe the sky is falling, but here's how we, redirect, where this is the space we still have to operate. What do you advise on that, particularly for an organization like American Progress?
Sure. And I will say, I don't see myself looking at the decision as narrowly as possible. I see myself looking at the decision as the court wrote it. And what the court said was that the two universities' admissions practices that were in front of the court violate the Constitution in Title VI. And so those practices need to change. I emphasize that because that's the law that I enforce. And so I need to be clear, and I hope school communities are clear, that if you recognize your higher ed admissions practices in what was in front of the Supreme Court in the Students for Fair Admissions case, you should change them because the court has said that they are unlawful. The court did not speak beyond that question. And the court said that it didn't speak beyond that question. I have to enforce the law as the court writes it. So to me, there aren't very many other options, right? The court did not speak to other questions. And so we don't have an answer from the court on those questions. And we do have decades of precedent that predate the court, unchanged by this court's decision, that we do need to adhere to and that my office does need to enforce. And there's plenty of limitation in those decades of precedent already. So, it's important to live within them. I think it's dangerous to read tea leaves in what a court says. The court didn't address that question. And so we can't ascribe to the court a view on it. The job of the Office for Civil Rights, assigned by Congress, is to enforce the law on the various kinds of facts that can come in front of us. And there are times that we have to say there is no specific precedent for this fact pattern. And so we are making our best judgment about whether the law does or does not allow those facts to exist. That's the hard work, right? And that's the interesting work. We love to do that, and we've been doing that for all these decades. We're happy to do that, but it's just important not to say that the Supreme Court in this decision said this if it didn't. And so that piece I think is important. For the rest of us, as we think about what do we do next, there is no question that the court's decision dramatically changed the lawful practices of a lot of places over 4.5 decades. So we are now in this new admission cycle needing to operate in a very different way. We had some time to think that was probably coming. So, that's the glass half full lens on it. And there are a lot of ways to admit and support and graduate students that are separate and apart from the admissions practice that was in front of the court. And we now know that we can't operate those ways anymore, but we were not told, we have not been told, it is not unlawful to engage in other practices that will achieve diverse campuses. And I know I benefited from a college and a law school that were looking for me and that were looking for my classmates who were nothing like me, who came together to have hard conversations, and that made it a richer environment. I want that for my daughter who's in college. I want it for my child who's going to go to college thereafter, and I want it for all of your kids, right? I mean, that's what builds effective communities. That's what sustains people's ability to be prepared to vote and to participate in our governments. And so I think they're important. As huge as the decision is in terms of changing practices at schools, there's also an even huger universe that it didn't touch. And I think we should be focused on what's available while having absolute fealty to what the court says we cannot do too, and not do that thing anymore, right? So to me, I mean, there's lots of opportunity. That's maybe sad that all that opportunity was there and we weren't availing ourselves of it as a nation. But here it is now. And we still have the imperative to educate and prepare diverse student bodies for the diverse world that we live in.
We have a question from the online audience over here. This is from Congresswoman Sheila Jackson Lee's office. And her staff person asks, you've spoken on how education could play a role in promoting social mobility and reducing inequality. What policies and strategies do you think will be the most effective in achieving these goals, especially in the aftermath of the court's decision?
Well, you know, I'm an all-in person. So I think we should be working on all of the fronts all of the time, every day. And that is sometimes frustrating to my staff and sometimes frustrating as maybe non-response, but I actually mean it, that when I say that no child has a minute to waste of learning, I mean that. And so for our focus on schools and what are the most important strategies to make sure that schools can be the inclusive communities that we promise that they will be, all of them. We want the teacher in front of the class to be prepared, to be a teacher, to be ready to nurture the gifts of every student in the class, to recognize that every student brings something to the school, to not be pushing kids out of school, but to be sending a message that school is for you. We want the school leadership to be instructional leaders, to be visionaries, to be planning for a school environment that's ready and that offers the full range of resources that should be available to them. We want higher education to be accessible and available and affordable for all of us. I mean, all of those things are incredibly important. So for me, stop sleeping, stop resting, go volunteer and do the work. I mean, and I don't think we should be picking because there's no part of the educational endeavor that isn't incredibly important. And I will, again, bring it home to my kids. My oldest, the one in college, is a scientist, which I completely don't understand, and, she loves her labs and she's so excited about what she can do. And I mean, all I wanted in college was not to have to ever go to another lab, but so that means we show up in the world in totally different ways and we have different gifts, different aspirations, and all of us should be bringing whatever it is that we have to making the fabric of our society work. And our school communities should be prepared to support that, period.
Thank you. I have one more from the virtual audience. This is from Nicole Hochsprung from the American Federation of Teachers. She says, we at AFT are hearing more and more from faculty who are involved with graduate student admissions, which is usually a faculty-led process. Despite the comprehensiveness of the process, some college administrators are instructing faculty not to ask about race, not to consider race at all, an apparent overcorrection in our read of the SCOTUS decision.
My read too, for what's
What advice would you give specifically to faculty and administrators involved in graduate admissions? Will guidance specific to graduate admissions be forthcoming?
So I never promise what we're going to issue. So, I'll make the announcement when I have an announcement on that. So I will just give you my standard non-answer on that. But on the more specific question, the court did not tell admissions officers to ignore race. It did not. And it did not say that Harvard or UNC or any other school needed to not know or unsee what it sees in the students' files. It did not tell students that they could not talk about race in their own admissions essays. And in point of fact, it said they could. Like, it answered that question explicitly. And I think a fair ancillary or corollary to that is that guidance counselors could write about kids' race if they wanted to, and other recommenders could write about that if they wanted to. But there's nothing in the court's opinion that said that the experience of a person applying to the school, including that person's race, cannot be accounted for as part of the admissions decision in the admissions decision making. So that is very much an overread of the court's decision, and it's definitely not legally required that schools not consider who their applicants are as they are making decisions about whom to welcome into their school communities.
Any other questions in the room?
I love this not shy audience.
Hi, my name is Madison Weiss. I'm on the higher education team here at CAP. So thank you so much for this wonderful conversation today. So my question is around the civil rights data collection. We know provides a really user-friendly way to find information on student access to particular resources within the elementary and secondary schools. So does the OCR have a similar resource reviewing info about colleges and universities? And if not, is that something that your office might eventually pursue?
Well, I would love it. I love data, and I so appreciate your talking about the civil rights data collection, which I will tell you is coming out soon. And I'm very excited to be able to share what we see in the most recent data. Also, I'm excited and sad because there's a lot of inequality, but we knew that. And I think it's important to be able to use it among all of our communities. And I really appreciate the point that you made too, that it's successful. And that's relatively recent. That was a change that my predecessor and the Obama administration made for the data. So there wasn't just something that we used. We have been collecting the civil rights data collection since 1968, and we've been using it in our civil rights enforcement. But Rustin Ali, who was the Assistant Secretary for Civil Rights before I was in the Obama years, made it more transparent and more accessible externally so that more people could use it. And I love that about it. And so I'm delighted that people are using it. I would welcome having parallel data in a parallel data look into institutions of higher education. There are some statutory limitations on our ability to gather that. So I heard that Congresswoman Jackson Lee's office was on, which is very exciting. Maybe there will be a statute that gives us more authority on this at some point. But there's also expense associated with it. And the civil rights data collection is among the more expensive endeavors in the Office for Civil Rights. And we are budgetarily limited as it is now. We have the president called for a 27% increase in our budget, which I would really welcome. That would allow us to bring another 150 people to do enforcement, to be able to create a new biannual massive data collection that we are able to then clean up and make public. We would need some more millions of dollars to be able to do as well. But I would welcome it. I mean, I think that we do a lot with the data that we have. That is the civil rights data collection, which is P12, and I would certainly welcome to be able to have that kind of look at and information about the experiences of students in higher education as well. Yeah.
Hi, I'm Allison Gill with American Atheists. So there's been a disturbing proliferation of book bans across the country in different, schools, particularly targeting, Black authors and LGBTQ authors and issues. And so I guess I'm curious, have you seen an increase in complaints on those issues first? And secondly, what can the office do to address that? What is the office doing to address those issues?
So Allison, we've seen an increase in complaints, which isn't saying that much because we hadn't seen any complaints on the topic, but also because there really weren't book bans of this type that there haven't been for some decades. And that's a cycle, a disappointing cycle in American history, but it is a cycle for us. And we're back in the part of the cycle where book bans are a very present part of the education conversation. The resource that we released last week talks about the racially hostile environments, sexually hostile, well, it was racially hostile environments there, but sexually hostile environments are also relevant to the book ban question, as you mentioned. And that's the lens through which we would be able to examine operation of the ban. We don't, as I mentioned, have statutory authority to determine what curriculum is offered in a school. We do have a statutory mandate to address the existence of a racially, sexually, or disability-based hostile environment that can exist in a school. And if curricular choices cross over into that, then that's something that we must investigate and address where needed. We have several cases in investigation on the topic now. We have resolved with one school district recently on the topic, and there the terms are specific to what was happening in that district, but there the district had already in place a very inclusive policy. The district had not followed some statutorily required steps. The Title IX regulation, which is the sex discrimination, the regulation about the sex discrimination statute that we enforce, as amended in the Trump administration, requires that when a school community knows about possible sexual harassment, a possible hostile environment, the school community must inform the possibly affected students how to file a complaint, how to reach out to the Title IX coordinator, and available supports. And that district didn't. So there was a pretty textbook concern there about a need to act. And so, we've asked the district to make sure that the students know about the Title IX coordinator, the Title VI coordinator, and also what supports are available, and to assess whether they need to take action to address a possible hostile environment there. So, that would be the lens that we would and could access the question. And I am dismayed by the number of times that people have felt the need to come to us about it, because they are feeling like the selective bans of particular books in their schools and their school communities is impacting their ability to learn.
This will be our last question.
Hi, my name is Rihanna Saslow. I'm with Education Reform Now. I was wondering how you advise schools and districts to implement proactive solutions to harassment in very polarizing age where teachers don't feel comfortable or outright not allowed to discuss race and gender in the classroom.
So your question breaks my heart. Let me just start. Some things are hard for me. My job is law enforcement, and so I am not commonly in the business of advising people about proactive steps to take, because I am commonly in the business of telling them the things that they need to do when they have violated the law. There are steps that schools can take and educators in schools can take to ensure inclusive environments. And I welcome it when schools are thoughtful about how to make sure that everyone in their midst can learn and can be respected and valued for who they are. Those include not communicating to students that they are unwelcome for who they are, not communicating to students that the educator in the classroom, that the school tolerates harassment based on who students are. There are kinds of things that I've seen school communities do that are inclusive, that work well, that include making sure that the examples that they offer, the materials that they teach about reflect a range of ways that kids might show up at school, and the ways that students might show up as learners. Those are kinds of steps that can take. I can tell you the things that we would require a school to do if they have discriminated, and they would certainly need to be. The law is that they must be enough to redress the harm that has taken place. So certainly they would want to be fact specific, and they would want to be responsive, but they often would include analyzing data, collecting information from students about impact on them, and then they might offer counseling, they might offer training for school communities, they might offer educational materials that talk about prevention, that let people know how to be an upstander and how to be part of an effective school community that is supportive. But the lens that I bring to it is the enforcement lens, and so it is the what must you do to correct this thing that you have done that has harmed someone.
I want to thank you so much for being here and joining us in conversation. Just thank you for your time and thank you for your work.
Thank you. Thank you all for coming and listening too. I really appreciate it. Thank you. Thanks for having me. Yeah.